Yes.
Exemption from
Yes.
surrender. IE number
5359.
where have you stated?
Sorry, madam.
Where is your statement in the IE?
But IA I had stated only 50%, but in the last order sheet I agreed to 100%.
So you will deposit 100%.
As well as simple. Para 10 I have stated. Page 9 of the IA.
That has also been recorded in the last order of your lordship dated 8th February 2000.
So you abide by your submission.
Mine.
Criminal Revision number 509 of 2022. The learned counsel for the petitioner and opposite party number 2 are present. This revision has been filed against judgment dated 8/3/2022, passed by learned Additional Sessions Judge Roman 2 Godda, whereby the appellate court has been pleased to uphold the judgment of conviction and order of sentence dated 25/11/2017, arising out of in complaint case number 364 of 2011, corresponding to TR number 2470 of 2017. The petitioner has been convicted for offence under section 138 of Negotiable Instruments Act, read with section 417 and 418 of Indian Penal Code. And your sentence is under 417-18 also,
Only 130.
and has been the petitioner has been convicted for offence under section 138 of Negotiable Instruments Act with a sentence of simple imprisonment of 1 year 6 months and compensation to the tune of rupees 30 lakhs. And in default of payment of compensation with the imprisonment of further period of 4 months. The learned counsel has submitted that one interlocutory application being IA number 5359 of 23 has been filed in the present case seeking exemption from surrender. The learned counsel submits that in paragraph 10 of this petition, it has been stated by the petitioner that the petitioner is ready and willing to deposit 50% of the compensation amount to show his bona fide, and he is seeking exemption from surrendering in view of the fact that the mother of the petitioner is critically suffering from cancer and undergoing treatment at Mumbai. The learned counsel has also referred to order dated 8th of February 2024, wherein the following submissions was recorded. The learned counsel submits that the petitioner is still ready to abide by the submissions made on his behalf on 8th of February 2024 and deposit the entire compensation amount before this court by
Monday.
Monday. The learned counsel appearing on behalf of the opposite party number 2 has no serious objection with regard to the petition seeking exemption from surrender if the petitioner deposits the entire amount before this court. We will give you the details of the bank account of our, or you will deposit it by DD.
May I say, subject to consideration? Because DD or deposit, that will affect the liquidity. May I be permitted to deposit a check?
No, check.
As my lord's proposal.
You have to deposit it directly in the bank account. You deposit it in the bank account. We will give you the details of the bank account of our Registrar General, and then we will direct that you will give the proof of deposit to the learned Registrar General, and then he will ensure that it is kept in a short-term fixed deposit, such that interest accrues on that, and we will very shortly decide it. We will not keep the matter pending over here.
Then, my lord, may I seek only further 2 days time, my lord?
Yes.
Till Wednesday?
Till Wednesday. Right. बैंक अकाउंट डिटेल्स हम लोग के हाई कोर्ट का होगा ना आजी साहब का. आप डिमांड ड्राफ्ट जमा कर दीजिए in favor of Registrar General.
Madam, grant me only 1 minute. I'll just inquire from my client. Madam, grant me
I'll
only
give you
1
1
minute.
week time.
No, I'm asking only 1 minute to inquire from my
Okay.
client. By the time Madam, I pass the order, I'll just inquire from my client.
ठीक. Considering the aforesaid submission and the nature of the case and the submission and statement made in paragraph 10 of the interlocutory application that the mother of the petitioner is critically ill and is suffering from cancer and undergoing treatment at Mumbai. IA number 5359 of 2023 is hereby allowed, subject to deposit of the entire compensation amount of rupees 30 lakhs in the account of learned Registrar General, Jharkhand High Court Ranchi, at the whose देखते हैं वो क्या बोलते हैं बैंक ड्राफ्ट को क्या. I think RTGS is better.
We can immediate transfer
Through demand draft in his favor or through account transfer. क्या बोल रहे हैं RTGS करेंगे?
Prepare the demand draft.
Demand draft. A demand draft in favor of learned Registrar General, Jharkhand High Court Ranchi, within a period of by Friday next, upon deposit of the said amount, the learned Registrar General is directed to keep this amount in short-term fixed deposit so that this amount may carry interest. Let the IA number such and such is accordingly disposed of. In case the amount is the demand draft is not deposited within the stipulated time, the present order shall stand automatically recalled, and the petitioner shall file the surrender certificate within a period of 1 week thereafter, failing which this petition shall stand dismissed without reference to bench. Call for the lower court record. In the name of Registrar General, Jharkhand High Court Ranchi, यही होगा ना नाम? किसके नाम से जाएगा?
Verified. It may not may indicate that in the order it will be.
We will indicate that. जरा पता कर लीजिए. DD किसके नाम से? ठीक. Exactly नाम उसमें डाल देना. LCR आ गया है?
जी.
कब बहस करेंगे? जमा कर दीजिए, उसके नेक्स्ट डे बहस करेंगे. ठीक है? If the demand draft is deposited within the stipulated time, let this case be posted for final disposal on कौन सा डेट बताइए?
First week of April.
आप अप्रैल पहुंच गए हैं तो ठीक है, 4 अप्रैल, हम लोग थोड़े इतना दूर सोचते हैं। ठीक है,
My lord, I was only just asking for a clarification. my lord.
देखिए
Next
कोई भी
Friday-
पैसा जो है ना
जी
बैंक अकाउंट में पड़ा किसी के काम का नहीं, इसीलिए कोई भी पैसा यहाँ जमा करने के बाद उसको हम लोग ब्लॉक नहीं करना चाहते। ये आपने जमा कर दिया है, आपको अगर करना है, क्या मैटर है, बेसिकली क्या इशू है बताइए।
The parties are partners, were partners,
ओके,
working under partnership. I lodged a sanha regarding loss of my checkbook.
ओके,
After 2 years of my sanha, the check was presented by the partner, and it was reported that the account is closed. And there are defenses, my lord. On the merit, I have got a 20 number of defenses. I have already prepared my
Must-
legal submissions.
okay. There was the partnerships to dissolve.
It was dissolved on
When?
2 months prior to the presentation of the check.
2 months prior to the presentation.
And the partner also, even after dissolution of the partnership, the partner was having a joint account with the petitioner, current account of 150 crores operation.
They used to draw the check. This check has been drawn on the account of the partnership firm,
This is from the personal account of the petitioner,
personal account of the petitioner.
not from that joint account.
What does he say? The check was filled up.
No, he says I signed before him, but it was not filled up by me. He admits that. But one very glaring fact, my lord, which is reflected from the essay, deposition, and complaint, even the legal notice, that the quantum of legally payable debt against which the check was issued, that is nowhere indicated as to what was the exact amount against which the check is being paid, handed over. It is vague.
You denied the debt completely.
Yes.
सुन लिया आप?
I'll apprise you also next year.
अब इनको तो 1 महीना अपना पैसा ब्लॉक करना है, तो हम क्या कर सकते हैं?
My lord, I was saying 8th of Friday is holiday on
छोड़
account of
दीजिए आप।
Shivratri.
4 तारीख को फिक्स कर दिए हैं, आप अपने किस्मत पे भरोसा रखिए। चलिए,
My lord.
Also case item 26 criminal division 1144 of 2022.
एक चीज और लिखिएगा, since huge amount is involved in the present case and the amount has been deposited before this court finds it proper to fix a date for final disposal in the matter. Accordingly, post this case under the heading for final disposal on 4th of April. A copy of the LCR has already been received. Photocopy आया LCR का?
Scan तो यार।
स्कैन कॉपी, चेक दिखाइए तो। आपने LCR देखा?
जी निकाल दो।
Sanha entry has been exhibited.
Yes. Approved by the officer in charge and also the Havaldar.
Both the courts have convicted you on account of presumption.
My lord, they have gone to the extent of applying the principle of proof beyond doubt on the defense. And that check, my lord, will see there are 2 pages, backside also is on the next page. There are 6 signatures of
It
the
has been
petition.
issued in the name of one company.
Yes, the complainant claims to be the proprietor of that company.
You had no business dealing with this?
I was dealing as a partner in person with the complainant.
No. It is one thing to say that there is a partnership firm. It is
Yes.
another thing to say that there is one partnership firm and there is a proprietorship firm also.
Yes, my lord, the second aspect.
Second
a partnership firm in the name of the petitioner, Mrs.
And
Sanjeev Kumar.
proprietorship firm in the name of this. And there was no business dealing with between you?
No, not even amongst the juristic persons. My partnership firm was not dealing along with the proprietorship firm of the complainant. The complainant was in individual capacity my partner, not his firm.
चलिए, तो सरफेस की बात है, पता चलेगा रिकॉर्ड से कि ये क्या है आपको। ठीक से समझ लीजिएगा अपने क्लाइंट को बैठा कर।
Item 26.
Call him and understand what is his case.
that the
This is very common that there is a partnership firm and they are dealing with individual proprietorship firm belonging to the partners. It is something which is very, very common in commercial world. Right? Yes.
name which is raised objection that the name is not correct, that has already been corrected by the lower court and subsequently, because my application was, it was correct, but in the
Okay, anyways, he is ready to deposit. आप बताइए।
हम दे दिए हैं, इनको पूरा डिटेल भी दे दिए।
दे दिए हैं?
हाँ, अकाउंट नंबर
कल जमा कर दीजिए, परसों रख दीजिए।
1 week at his time maybe lordship because he is there lordship and he is residing at Jamshedpur lordship.
पुअर आदमी को पुअरर मत बनाइए।
आपको रखने के लिए पूरी तरह से रेडी थे लेकिन ये नहीं रहने को तैयार है।
अभी 63,000 रुपीस देंगे
हाँ,
प्लस वो भी तो 62 भी तो अभी आपका जॉइंट डिवोर्स पिटीशन फाइल हो रहा है आप लोग का।
अभी तो संपर्क नहीं करते हैं, तो नियम पे भी वहाँ हो जाने के बाद रोज मेरा नाम पे ये मीरा है कि मीना है, उसी पे ऑब्जेक्शन करते रहते हैं।
तो 63,000 रुपीस जो आप जमा करेंगे तो आपका करंट
Account
मेंटेनेंस
number
बंद
दे
हो गया, करंट मेंटेनेंस बंद हो गया।
आज तक 1 रुपया दिए ही नहीं, तो ये 189 का डिस्ट्रेस वारंट इशू था, 1 रुपया भी नहीं दिए थे, तो हम लोग मतलब टू गेट रीड ऑफ दिस ऑल इट वाज कॉम्प्रोमाइज, और 189 का डिस्ट्रेस वारंट इशू था, उसके बावजूद भी 125 का उसके बाद कॉम्प्रोमाइज के बाद 1 साल हो गया और पैसा नहीं मिला।
ओके,
नहीं कंप्रोमाइज हुआ 19
बैंक
5
अकाउंट
23
डिटेल्स दीजिए।
दे दी
उनको दिए हैं?
जी।
अच्छा ठीक है, इसमें ऑर्डर में लिखाएंगे, नहीं
लिखा-
जरूरत नहीं है।
लिखा
बस प्लीज हाथ में
द लर्नर कोई limitation has been condoned.
yes
It has just come for payment.
It is just come for payment. Earlier he was directed to pay some amount, that was he also not paid. वहाँ जाने पे भी इनको कुछ पैसा देना था, वो भी नहीं दिए। वहाँ कंसिलिएशन में भी नहीं दिए।
नहीं झालसा में 11 5 23 19 5 23
But
को ऑर्डर
the interim order granted on 24th,
उसके बाद मैटर झालसा में चला
फिर भी
गया।
एक पैसा नहीं दिए।
19 5 23 में फिर ये फिर से रिव्यू हुआ पैसा का।
25th April 23 को कोई interim order हुआ था।
हाँ
हाँ इसमें इंट्रीम ऑर्डर 20
So the
24th
interim order has vacated because you have not paid any amount.
no because the matter was again referred before the Jhalsa lordship. अब
No.
फिर पैसा का फिर से रिव्यू
No,
हुआ।
the interim order granted by the order dated 24th February 2023 shall remain in force subject to fulfillment of the condition as imposed by this court in order dated 24th February 2023.
Since the again matter was referred before the Jhalsa lordship, but Jhalsa में फिर दोबारा रिकंसिडरेशन करके फिर
दोबारा तो यही से गया था ना 12/4/2023 से।
यस लॉर्डशिप
So
12/4/2023 के उसमें फिर से रिडिटर्मिनेशन हुआ, फिर पैसा का फिर 1,25,000 में दोनों पार्टी कंप्रोमाइज कर लिए।
your
उसके बाद देयर आफ्टर दिस मैटर वाज नेवर लिस्टेड बिफोर दिस ऑनरेबल लॉर्डशिप।
what about this travelling allowance etc.
वो भी नहीं दिए हैं। वहाँ जब हम लोग
Why
गए
are you not
थे,
paying
नहीं,
this?
ऐसा
You
नहीं।
have to comply this order 25th April 2023.
ये ट्रैवलिंग अलाउंस जो
नहीं बिल्कुल नहीं मिला है, नहीं मिला है। हम मांगे थे, हम गए थे, ऐसा बिहेव कर रहा था जैसे कि हमको दे रहा है।
For each and every date of mediation, you will have to pay that amount.
ये यस लॉर्डशिप हमको जो इंस्ट्रक्शन है कि वो जमा किए
नहीं
ऐसा किए
किया, नहीं किया। वहाँ लिखा हुआ होता है, एक पैसा नहीं।
अब joint compromise फाइल करेंगे इसमें क्या
Yes.
करेंगे?
जॉइंट
So
कंप्रोमाइज
far as this case is concerned.
जितना भी ऑल द मैटर्स व्हिच आर पेंडिंग लॉर्डशिप।
आप
There is
यहाँ
only
जाके-
this
हाँ,
case
ये-
is pending.
यहाँ एक सिर्फ यही केस पे
नहीं एक केस हम भी किए इनके ऊपर में, उसको भी हम विड्रॉ करें, दोनों पार्टी विड्रॉ करेंगे।
No, you have to file a joint petition for divorce.
यस
वो आप कब करेंगे?
आफ्टर 3 वीक्स लॉर्डशिप फर्स्ट इसको हम पैसा जमा कर देते हैं 1 वीक के अंदर।
ठीक.
उसके बाद
Learned counsel for the parties are present. The learned counsel submits that the matter was sent for mediation by the order dated 12/4/2023. And as per the mediation report, the matter has been settled and the petitioner has agreed to pay first installment of rupees 63,000 on the date the case would come up for hearing before this court. And the second and final installment of rupees 62,000 will be paid on the date of filing of joint divorce petition before the concerned court. The learned counsel for OP number 2 has submitted that, for the opposite party has submitted that by the order dated 12/4/2023, an amount of rupees 1,000 for travelling and other expenses for the purposes of each and every date of mediation was directed to be paid. Even this amount has not been paid to the petitioner, to the opposite party number
2.
number एक ही है opposite
एक ही
party,
है,
to the opposite party. Upon this, the counsel for the petitioner submits that the entire amount of rupees 63,000 would be deposited in the bank account of the opposite party number 2.
हाथ में लिख लिया,
Uh,
पंजाब नेशनल बैंक अकाउंट है, हैंड में हम उसका लिख दिया।
the detail of the bank account has been furnished by the opposite party number 2 to the learned counsel for the petitioner during the course of the day, within a period of 1 week. He also submits that, as per his information, the amount of rupees 1,000 by way of travelling and other expenses on each date of mediation has been paid. But if that has not been paid, the same will also be remitted to the bank account of the opposite party. The learned counsel further submits that once this amount is paid within a period of 3 weeks from today, within a period of 3 weeks thereafter, steps will be taken for the purposes of filing joint divorce petition in terms of the joint divorce petition before competent court. The matter is adjourned and is directed to be posted on March 14th 24. The amount of rupees 63,000 and rupees 1,000 for each date of mediation when the opposite party number 2 attended the mediation be deposited directly in the bank account of the opposite party by next Friday. And an affidavit be affidavit करेंगे? An affidavit regarding deposit of the amount be filed before this court. Post this case on 14th.
Since I am not aware how many dates possible.
3 dates था, 3 dates से ज़्यादा नहीं।
During the course of argument, the learned counsel for the opposite party has submitted that the opposite party had attended mediation on 3 dates.
I'm very sorry to interrupt you. My lord had directed to be deposited by Friday. My lord, my only concern is, my lord may indicate the date also because tomorrow is also a Friday.
Oh, Friday नहीं भैया, अगला Friday का date. हाँ, एक हफ्ता का date का complete करना. We'll put the date. कौन सा date हुआ अगला Friday?
8th.
8th. आप कर दीजिए टाइम से. You carry a risk.
Also case item 27, Kinnarujan 9
लेकिन आपका केस इंटरेस्टिंग लगता है.
I tried to contact the petitioner. His son was in contact with me. He is only saying that पापा निकलेंगे तो ही पैसा कमाएंगे. So my prayer is that Your Lordship let him be out on bail. Then only we can deposit some amount. Because he is the only brother.
What is the check amount?
3 lakhs, Your Lordship.
3 lakhs.
Yes.
You are seeking bail?
Yes.
We will give you bail subject to deposit of 20%. 20% जमा करिए, हम आपको bail देंगे.
हमको इसी पॉइंट पे
इंस्ट्रक्शन का जरूरत नहीं है, वही ऑर्डर करेंगे, कर दीजिएगा तो बहुत खुशी की बात है, नहीं तो आराम से 6 महीना का सजा हुआ,
जी जी
सस्ते छूटेंगे.
इसको
6 महीना
Tuesday
बिता
को
दीजिए
रखा
जेल में.
जाएगा. only till Tuesday because वो लड़का है वो
नहीं.
समझ नहीं पा रहा है इस चीज को. I'll call the
कोई बात नहीं कोई बात नहीं. देखिए अब वो अभी लॉ में अमेंडमेंट हो गया ना, हुआ है ना, पता है कि नहीं पता है? नहीं पता है तो थोड़ा पता करिए. देखिए IA नंबर 2123 of 2024. This petition has been filed against ये दोनों petition के IA number 2123 of 2024 with criminal revision number 938 of 2022. The criminal revision has been filed against order of against the appellate order confirming the conviction of the petitioner for offence under section 138 of Negotiable Instruments Act. The petitioner submits that the learned counsel for the petitioner submits that the petitioner is in custody in connection with this case, and interlocutory application has been filed for suspension of sentence and for releasing the petitioner on bail. The check amount involved in the present case is for
3
an
lakhs.
amount 3 lakhs, and there is a compensation amount of rupees,
6 lakhs.
and the total compensation fixed in the present case is rupees 6 lakhs. What is your for one line of your case?
Your Lordship,
No legally payable debt.
no legally
The
payable
learned
debt.
counsel for the petitioner has submitted that there was no legally payable debt, and accordingly the conviction cannot be sustained in the eyes of law. After opposite party?
No,
State. The learned counsel for the state submits that notice is required to be issued to the opposite party number 2. After hearing the counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that the petition the IA number 2123 of 2024 is allowed, and the sentence awarded against the petitioner is suspended, and the petitioner is directed to be enlarged on bail upon furnishing of 2 sureties of 25,000 each. One of the bailers should be close family member of the petitioner. Aadhaar card is to be deposited. The phone number is to be furnished. And further, the petitioner shall deposit the 20% of 6 lakhs amounting to rupees 1,20,000 prior to while furnishing the bail bond. The aforesaid amount be deposited before the learned trial court and is directed to be kept in an interest-bearing deposit. Issue notice to opposite party number 2
I need to implement the
Under-
opposite party number.
registered under speed post as well as ordinary process. Opposite party number 2 बनाया नहीं है. At this learned counsel for the petitioners seeks permission to add opposite party number 2, the complainant as opposite party number 2 in the present case. The needful be done in writing during the course of the day. Issue notice to the opposite party number 2 under speed post as well as ordinary process for which requisites be filed by Monday. Frame. Office to track speed post delivery. Post this case on 25th April, awaiting service to follow. Let this order be communicated through pass. IA closed.
This case of panel resolve item 1, WPS 1084 of 2023.
So one senior colleague of mine just now told me that the concept of Bal Arakshi, that has been given, concept and provision of Bal Arakshi that has been given in police manual. Yes, I could not do that almost, but Mr. Dubey had just now told me. But here is the case, what has happened in 2000.
No, you want to argue or you don't want to argue?
No, Lord. If
You
Malos-
can't have it both ways, no?
If Malos could accommodate for only one day, it will be tomorrow. I just wanted to go through that provision, my lord. बिहार पुलिस में खाली कल के लिए रख दिया जाए.
ठीक है.
I'll do it tomorrow morning.
Counsel for the petitioner seeks adjournment. Post tomorrow.
Great.
Bal Arakshi is a compassionate appointment
It's
under
a
police
compassionate
manual.
appointment, my lord.
Is that so? एक केस मैंने डिसाइड किया है बाल आरक्षी पर. हमको याद नहीं है.
हम सर्च कर लेते हैं.
I don't remember.
सारे में सर उस दिन जो आप बोले थे आप
एक केस हम किए हैं बाल आरक्षी पर.
नाम से
नहीं
search
मिला
कर
क्या?
लेते
नहीं मिल पा रहा.
बस उनको लगाइए. उनको लगाइए.
Item 25.
Or I
criminal
must
vision-
tell you, as I remember, it is on compassionate appointment.
Lordship, the matter has been
Item 35.
खोजिए.
the matter has been infructuous as the trial has been concluded in this matter.
Criminal revision number 192 of 2022. The learned counsel for the petitioner, Mr.
Rahul Basak,
Rahul
Basak, BSA,
B.A.
SAK, Basak.
Basak, under instructions of advocate on record, seeks permission to withdraw this petition by submitting that the present petition has become infructuous. Considering the submissions, this petition is dismissed as not pressed.
Item 36, criminal vision 199 of 2022.
In this case, the petition happens to be the wife. Now, she had lodged a case under section 498A, 313 and other sections of the Indian Penal Code. And subsequently, charge sheet was filed. Then cognizance were taken, that is the Annexure 2, under section 498A and 313 of the Indian Penal Code. Against that order, lordship, the opposite parties 2 to 7, they filed an application for discharge. That order is at Annexure 3, page 33. Now, I am agreed by only one portion of the order, lordship, by which all these opposite parties, they have been discharged of the offence under section 339. Now, if your lordship will kindly see, page 36, running page 36, lordship, as far as section 3 and 13 is concerned. As your lordship. Yes, the last paragraph. Thus, considering the fact, evidence and circumstances discussed above, and also considering the material available in the case diary, it appears to me that in this case, cognizance for allegedly commission of offence under section 498 and 13 IPC has been taken by the court, and accordingly, case record has been committed to the search. Now, so far as the offence under section 313 IPC is concerned in this context, in my view, to frame charge under section 313 IPC, there must be such material in the case diary or case record which prima facie speak that at the time of alleged incident, victim was pregnant and said pregnancy was terminated by the act of accused person. But in the present case, there is not a single sheet of medical paper to show that the informant who is the sole victim of this case was pregnant and her pregnancy was terminated. The informant in a written statement simply stated that in the month of June 2015, the accused person possibly administered some medicine to her which causes the termination of the pregnancy. At the same time, the informant in a reinstatement fails to disclose any date or month or year on which her pregnancy was terminated. Moreover, according to restatement of the informant, said medicine was prescribed by the doctor of TMH, but prosecution failed to produce any such prescription. In my view, to bring charge under section 313, existence of medical evidence.
Yes, there is. It's a case of no evidence for 313.
No, it's a case. It's a purpose finding of the court below.
Okay. What is your medical evidence? The medical evidence there is on record.
It is there on record in the case diary.
Where is the case diary?
Lordship, case diary was not proper in this case.
Where is the case diary in this case?
No, all these things which your learned judge has said has to be seen at the time of trial. Whether I was
If there is
pregnant.
No. At least there should be some material
Yes,
to say that you were pregnant.
There
Your
is.
statement is not sufficient.
No, it is in the
Either
diary.
you should have some medical report showing your
It is
pregnancy.
in the diary, in the TMH. It is said that cervical length, it says 1 month. It says that. So how the learned judge has said, even the informant as well as the parents, they have also
Notice was
stated.
issued.
Yes.
Who is for the opposite party?
There.
Where is the case diary? You have filed a counter affidavit. It's an FIR.
Yeah.
You are there for the OP?
Yes, sir.
Yes. He says that it's perverse because there is evidence of pregnancy in the
No, Your
case
Lordship,
diary.
there was no any finding either in the case diary, Your Lordship, nor in records, Your Lordship.
Where is the state? State has not been called upon to file a counter affidavit.
Only notice was issued, Lordship.
Only notice.
You produce a case diary, we will see the case diary.
Because paragraph 13 of the case diary specifically has that.
Para 13.
Yes.
देखिए, the learned counsel for the parties are present. The learned counsel for the petitioner has submitted that by the impugned order, the opposite party number 2 has been acquitted for
227.
offence.
227.
Sorry.
227. Opposite party numbers 227.
Opposite party number 227 has been acquitted for alleged offence under section
Discharge, Your
313.
Lordship.
Discharge.
Okay, have been discharged for in connection with alleged offence under section 313 of Indian Penal Code. The learned counsel, by stating that there is no evidence with regard to pregnancy of the petitioner. The learned counsel submits that the matter was investigated by police, and in paragraph 13 of the case diary, the medical document is on record to suggest that the petitioner was pregnant at the time of occurrence. The learned counsel for the state is directed to seek instructions and file a counter affidavit in this case, and also produce a copy of the case diary. Case diary original produce करिए.
Original.
क्योंकि पे मेडिकल डॉक्यूमेंट ऐसे पढ़ाता नहीं है.
Original तो कोर्ट में होगा देख लेंगे.
कोर्ट में होगा.
Original कोर्ट में है.
Get a copy.
इसमें साफ है, पढ़ा जाए.
Type copy. Type.
ये जो है फोटोकॉपी भी साफ है, पढ़ा जाए.
अच्छा ठीक है.
ये हमको जो मिला.
And produce a copy of the case diary. कहाँ का मैटर है? Jamshedpur. Let the counter affidavit be filed by 7th March. Post on 13th. 14th March.
10th March तक
10th तक 14 तारीख को डेट दिया 10th March तक आप फाइल कर दीजिए and produce the case diary also. The medical document, the medical document as if mentioned in the case diary be also annexed along with the counter affidavit.
medical
अगर उसमें कोई मेडिकल प्रेस्क्रिप्शन है तो आप काउंटर एफिडेविट के साथ लगा दीजिए.
That is with regard to pregnancy only.
ओनली प्रेगनेंसी. और इनको कॉपी सर्व करके फाइल करिएगा नहीं तो ये अगला डेट में टाइम मांगेंगे. यू वांट टू फाइल एनी काउंटर एफिडेविट?
Your Lordship, we have already filed.
Item 38, Criminal Division 253 of 2022.
Yes.
Here the petitioner has approached this honorable court against the order dated 15/2/2022, passed in maintenance case number 98 of 2018, by which the maintenance case filed by the petitioner under section 125 CRPC has been dismissed by the family court. The maintenance case was dismissed on 3 accounts. Firstly, that the opposite party of the case, husband of the petitioner, is a senior citizen. Secondly, that he has given 4 cattle to the petitioner. And thirdly, the sons of these petitioners are also armed. These are the 3 findings on the basis of which.
You are for OP number 2?
Yes.
Ready? Okay. LCR is not required?
LCR की जरूरत इसलिए क्योंकि deposition has not been annexed with the main application of the Miller's.
Counsel for the parties are present. Counsel for the petitioner submits that the maintenance petition filed by the petitioner has been rejected on grounds which are especially perverse. The learned counsel for the opposite party number 2 submits that the records of the court from the court concerned would be required in this case. Office is directed to call for the records from the court concerned. Let this order be communicated through fax. Post this case on 14th March under the heading for final disposal.
Item 39, Criminal Division 266 of 2022.
Time for what?
I want to know the status of the case before the trial.
इतना दिन से तो आप आ नहीं रहे हैं, है ना?
Discharge petition was rejected in 22.
केस तो पक्का प्रोसीड कर लिया.
हाँ. January 22 का order है.
You want to pursue?
More than 2 years have passed.
कुछ प्राइमरी फेसी केस बनता है कि
ऐसे तो ये सस्पिशियस बेसिस पर किया गया है. कोई विटनेस भी सीबीआई के भी इन्वेस्टिगेशन ऑफिसर हैं, उनको भी कोई विटनेस नहीं.
सर्कमस्टेंशियल एविडेंस में भी तो केस बनता है ना, कि नहीं बनता है? कॉन्स्पिरेसी का चार्ज में आपका डिस्चार्ज कैसे?
कॉन्स्पिरेसी का है चार्ज इनके खिलाफ में.
हाँ तो काफी है ना.
कॉन्स्पिरेसी भी
Police officials are involved in the murder of one person.
Other police officer was involved. I was not on the spot of the.
It's a case of 302.
Yes, sir.
302 FIR
बहुत
lodge.
सीरियस है ना, बहुत सीरियस ऑफेंस है.
केवल 5 ही.
देखिए हम नहीं करेंगे इसको डिस्चार्ज. 120B का जहाँ आ जाता है, it is very difficult to allow your discharge.
FIR law not under section 120B. FIR law under section 302 and 34 IPC.
That's right. Cognizance taken.
And charge sheet has been submitted under section 304.
You argue.
4A.
You forget about the stage. You argue the case. Yes, sir.
I will withdraw the
Criminal Revision number 266 of 2022.
with liberty to
At the outset, the learned counsel for the petition seeks permission to withdraw this petition. He submits that dismissal of this case may not have any bearing on his trial. Right? Counsel for the opposite party has no objection to the prayer for withdrawal. Accordingly, this petition is dismissed as withdrawn. However, withdrawal of this case will have no bearing on the trial.
साइन कर दीजिए
Item 40. Criminal Revision 787 of 2022.
Petitioner,
May I please, Your Lordship? The matter is of NI Act, my lord.
mediation report.
A mediation report has came.
Nobody participated.
Nobody, but my client is present today and he said that he will pay the rest amount whatever I due.
Rest amount.
Yes.
Rest amount means what?
Actually, at the time of getting the bail, he has deposited rupees 75,000 and during the trial period he has also deposited 29,000 and the check amount is of 2 lakh rupees. But learned trial court
Compensation amount?
learned trial court below has passed the compensation amount 2,31,000, out of which 2,21,000 is the compensation amount and 10,000 is fine.
So you want to deposit the entire amount?
He want to deposit the remaining amount because he has already deposited 75,000 during the bail and 29,000 during the trial.
We received 1,04,000 in total.
Okay.
We received 1,04,000. Rest amount if he pays then.
If he pays, you will find joint compromise amount.
Yes,
Petition.
Yes.
Why have you not filed it so far?
My lords, actually his son was ill and he was severe and he was treating his son. That's why he has not.
And did not participate in any dates in mediation as well.
You want money, no? So you file joint compromise petition giving the details.
My lords.
What is the check amount? How much was
We
paid?
will give by DD.
Alright.
Okay, my lord.
So your client is here?
Yes, yes, he is sitting.
He has come from where?
He has come from Kodarma, my lords.
Kodarma.
Yes.
Your client is also here?
He's not here.
For that we need some time, my lords, to arrange the entire amount. The 1,27,000 is remaining. So
1,27,000.
yes, 1,27,000 is not remaining.
1 week should be sufficient.
My lords, he's told me that 3 weeks time they will grant, so that he will arrange and we will file the joint compromise petition.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the petitioner has paid substantial amount against the check
My lords.
to the opposite party number 2 during the stage of trial
Trial and here also. In
and
revision.
by virtue of order passed by this court also.
My lords.
His client is present in the court and on instructions he submit that the petitioner is ready to give the balance amount, including that of fine amount, to the opposite party number 2 by way of demand draft, and is ready to settle the matter out of court.
My lords.
The learned counsel for the opposite party number 2 has submitted that if the entire amount as per the impugned
Which is your page number?
order
30?
is remitted to the opposite party number 2, he has no objection for a joint compromise. Considering the aforesaid submissions of the learned counsel for the parties, this matter is adjourned and is directed to be posted on 21st of March 2024.
My lords.
The joint compromise petition, if any, be filed latest by 19th March. You should annex the copy of the DD
Yes, yes, my lords. I
in
will-
his favor,
Yes, yes.
and you should check the spelling.
My lords.
It will be on the favor of the company.
दोनों का नाम
Spelling is also very important. We have come across cases गलत spelling से एक तो DD बना दिए.
Today we have seen one case also. The name by spelling mistake also.
Item 41, criminal vision 813 of 2022.
Yes, petitioner.
Against the order by which the maintenance amount has been awarded, but my only clear is that the maintenance amount which has been awarded is not proper. He is a government servant, and total 5,000, 4,000 to his wife and 1,000 to daughter. Total 5,000 has been awarded. Only my clear is
The
that
affidavit of disclosure was filed.
yes.
The affidavit of disclosure in terms of Rajneesh versus Neha versus Rajneesh.
Earlier, perhaps that was, I'm not sure about that, that was fault. But the finding given
Why
by
such
the
a less amount has been fixed by the court?
Yes, ma'am.
What is the reason?
He is an employee of the civil court, my lords, the opposite party number 2, and he pays 66, my lords, which is the finding given by the trial court with regard to page 66 in the middle towards the fact of the wife and the infant child facing financial crunch is also evident from the material on record, and it is both the social, matrimonial and legal obligation of the opposite party husband to maintain and look after his wife and child. Thus, it is amply clear and established that the petitioner indeed has the right to agitate her claim for demanding maintenance from her husband, opposite party number 2, as regards the quantum of the maintenance be awarded, considering the income of the opposite party husband of nearly 13,000 in hand per month as claimed. This court is of the view, firm view, the such and such. Thereafter, my lords, the amount has been fixed. My lords, my statement is also there, my lord, that he is an employee of the civil court, my lord. Hits after deduction, my lords, he was getting a sum of rupees. That is at paragraph 7 of my petition.
You must have claimed what was your claim before?
20,000 rupees per month.
And what, according to you, what was his salary?
Paragraph 7, my lord, as per my information that I have
No,
mentioned.
not information, as per the impugned order. We are in revision, you have to say as per the impugned order.
As per the impugned order, my lord, that is not specifically mentioned.
Page 61.
The last paragraph.
Yes.
It is further awarded that the opposite party draw a monthly salary of rupees 28,000, out of which a substantial part of it per month is deducted randomly from his salary by way of EMI deduction from the loan borrowed by the opposite party for the performance of his own marriage and other statutory deduction. He is
As per the judgment passed by the Honorable Supreme Court in the case of Rajneesh versus Neha, the affidavit of disclosure has to be filed by both the parties regarding your assets and liabilities. That has not been done.
Yes, please.
So therefore, this order cannot sustain. It has to be decided afresh after filing that affidavit.
Can I submit one thing?
Yes.
According to the judgment and the last paragraph of the judgment, that the petitioner has not laid any evidence to demonstrate or the documentary evidence of income of husband opposite party from his employment and other sources of as contended as per the version of the opposite party at para 24 of his deposition. He has not produced any documentary.
That's right. Therefore, the judgment of the Honorable Supreme Court says that you have to suo motu dispose.
You have to show that.
No, both parties will have to declare.
But here, both parties have failed.
Therefore, the judgment of the Supreme Court says that in all the pending proceedings also that was applicable and affidavit was required to be filed. We have remanded a number of matters on this count because the exact disclosure of the income is not coming forth in spite of the
That is
order
there,
passed by the
yes.
Supreme Court. So therefore that has to be done.
Now
But,
see, this petitioner has produced the documentary evidence also regarding his salary and also the deduction of the loan amount.
So everything, you have to disclose everything. You have to disclose.
But the wife, petitioner wife, has not able to establish the income otherwise. And Lordship, one thing also, this petitioner is employee as a treasury sarkar before the class 4 employee.
So he gets less than the minimum wages also.
No, but here is something. 3 lakhs rupees he has to deposit in terms of compensation to the wife. So that
therefore the
he
Supreme Court takes into consideration all the amounts which were directed to be paid, including there could be a maintenance amount in a divorce petition.
Yes.
There could be a maintenance amount in 125. There could be a maintenance amount in domestic violence. So everything has to be taken into consideration to quantify the maintenance such that the wife does not actually use these proceedings as a means to just extract money. Right? That is taken care of, but those disclosure affidavits has to be filed before the court and therefore it is required to be considered. This particular order has to be set aside. We will remit the matter, but in the meantime you pay this amount.
Yes, that
In the meantime you will continue to pay this amount.
Yes, of course.
And then this fresh adjudication has to be done.
Because this case is this order is the final order so far.
Yes.
Now.
देखिए, Criminal Revision 813 of 2022, this petition has been filed for the following relief. The Learned Counsel for the petitioner has submitted that the petitioner has no means of livelihood and has been awarded maintenance amount of rupees 4,000 for herself and rupees 1,000 for her child. He submits that the marriage is not in dispute. The Learned Counsel submits that the opposite party number 2 is an employee, is a government servant, and the amount fixed by the Learned Family Court is a meager amount and calls for interference. आपकी तरफ से लिखते रजनीश वर्सेस the Learned Counsel has also relied upon judgment passed by the Honorable Supreme Court in the case of Rajneesh versus Neha, and he submits that the said judgment, that pursuant to the said judgment, affidavit of disclosure was required to be filed by both parties, even in all pending proceedings, but such step has not been taken before the Learned Family Court, and therefore the impugned order calls for interference. The Learned Counsel, appearing on behalf of opposite party number 2, has submitted that the petitioner has been directed to be paid a sum of rupees 3 lakhs by virtue of order passed by this court in ABA number 4292 of 2020, and was regularly paying the interim maintenance of rupees 3,000 per month. She has also submitted that the petitioner has a huge financial liability for repayment of loan, and his take-home salary was only rupees 13,500. And considering this aspect of the matter, the impugned order does not call for any interference. However, from the perusal of the impugned order, this court finds that the required disclosure in terms of enclosure 1, 2, 3 as enclosed with the judgment passed by the Honorable Supreme Court in the case of Raziz versus Neha Supra has not been filed before the learned family court, and there is a dispute regarding the exact income of the opposite party number 2, and consequently and ultimately the learned court has fixed a total of rupees 5,000, 4,000 plus 1,000 bracket mein. Considering the fact that the directions contained by the Honorable Supreme Court in Re Nehar versus Rajneesh having not been satisfied, this court has not been complied. This court is of the considered view that the such affidavit of disclosure would have enabled the learned family court to come to a correct finding regarding the assets, liabilities, and for fixing the quantum of maintenance. Consequently, the impugned order is set aside, and the matter is remitted back to the Principal Judge, Family Court, Chatra. The parties to appear before the court on after 1 month. After 1 month का एक तो डेट डाल दीजिए. डेट अभी बताते हैं. On 4th of April. 4th April.
4th of April.
Yes, immediately after Holi. 4th of April 2024. And along with their affidavits of disclosure in terms of their procedure judgment. Citation रहेगा, उसको पढ़ लीजिएगा, उसका enclosure में पूरा दिया हुआ है data.
Yes, exactly.
Directions भी है उसमें, accordingly. Yes. Upon the appearance of the parties and filing of such affidavit, appropriate order with regard to maintenance be passed within a period of 3 months from the date of the appearance of the parties. However, it is observed that so far as the maintenance as fixed in the impugned order is concerned, the petitioner would be entitled to the same in terms of the impugned order, which will be subject to the final outcome of the maintenance to be fixed by the learned family court upon fresh adjudication. This petition is accordingly disposed.
Item 42, Criminal Division 815 of 2022.
May I begin? Fellows, this revision application is directed against the order passed by the learned court below, dated 16/6/2022, that is at page 29, wherein a petition filed on behalf of the informant had filed petition, lodged the state before the learned court below, under section 319 of the Criminal Procedure Code, to summon the accused person in this case, namely the petitioners. While the petitioners were accused in the FIR, police after investigation had submitted final report against them. Annexure 2 is the final report. And the court had discharged them. After the submission of the final report against them, the court did not take cognizance against these petitioners. Now, against the other accused person, against whom the charge sheet was submitted, they faced trial. And my lords, during trial, all the witnesses were examined of the charge sheet. Now, after examining of all the charge sheet witnesses in my humble submission, at the belated stage on the petition filed by the informant, the petitioners have been summoned by the learned court below under section 390. This is the gist of the case. Now, the points for Lordship kind consideration is the law points which we are reading, which has been taken into consideration by the Constitutional Bench of the Apex Court. Hello, sir. In my humble submission, if Lordship may kindly peruse section 319 of the Criminal Procedure.
I am aware of the provision. You proceed. I have read it. I am aware of 390. You just formulate your entire point. You also give the list of the judgments you are citing, and then we will come to section 3.
The points which we are formulating, my lords, number one, that whether the person who were accused in the case and the police, after investigation, submitted final report against the accused who were named in the FIR. And the learned court below did not take provisions against the person against whom the final report was submitted, meaning thereby they were discharged by the learned court.
Whether he can be made an accused under 319.
After?
Under 319.
319 of the Criminal Procedure.
This issue has been settled.
Well, this point has been settled since 1990 Supreme Court, and up to 2014 in the Constitution Bench of the Supreme Court has also taken the view, my lords, in my humble submission, in the case of my lords,
which is the most important judgment. There are numerous judgments. You just
yes,
cite one.
Hardeep Singh case. Hardeep Singh case is the Constitution Bench judgment on this point. That is 2014, Volume 3, SCC, page 92.
Para number?
My lords, in this case, my lords, this judgment of the Constitution Bench has been again considered by the Apex Court in the case, my lords, Labhu Ji Amar.
Citation, please.
My lords, I am giving the copy of the judgment of the Apex Court on this point, wherein this Hardeep Singh case has been followed.
So one Hardeep Singh's judgment should be sufficient.
And on this point,
yes, on this point,
two judgments I am relying.
Okay.
One, AIR 1990 Supreme Court. AIR 1990 Supreme Court, page 2158.
Party name?
Party name is, my lord, Sohan Lal and others.
2158.
2158.
Sohan
AIR.
Lal. Okay.
What
Then you
is-
have Hardeep Singh.
My lord,
Then you have Hardeep Singh. One Sohan Lal.
Sohan Lal and others, appellant versus State of Rajasthan.
Okay.
Respondent. The paragraph 14, 30 and 33 of this judgment are relevant on this point. And thereafter, whereas on this point, again I am relying a judgment of this Honorable Court. There are judgment of that court and the judgment of this Honorable Court also on this point. Just now I am giving one, I am sorry. Yes, ma'am. That is 2009, Volume 2, Eastern Criminal Cases, page 144.
Party name?
Party name is Velos Guru Chandra Gorai and others. Petitioners versus State of Jharkhand and others.
This is the only point involved?
Eh?
Is this the only point involved?
No, there is other point. There are other
You
points.
formulate your points and then we will hear you. This is the first point.
This is the first point.
What is the second?
Second point in my humble submission is that the appeals court has repeatedly held that if from the evidence which has been adduced during trial, on the basis of which the order under section 319 of the Criminal Procedure Code was passed, my lords, there must be, the court must be satisfied that on the basis of the evidence, there may be conviction against the accused person. It cannot be exercised in a casual and cavalier manner.
The litmus test is much more than prima facie case.
Prima
Much
facie.
more than that.
Yes, my lord is correct. There must be prima facie case, more than prima facie case.
Much more than that.
Yes. In this regard, my lords, we are relying on judgment of the Appeals Court AIR 2021 Supreme Court, page 5107.
Party name?
Party name is, my lords, Ramesh Chandra Srivastav versus State of UP and others.
That's right.
The paragraphs are paragraph 7 and 10 of the judgment is relevant.
All right. What else? These are 2 points. What is the third point?
The third point in my humble submission is that, my lords, at the belated stage, when all the witnesses were examined, then in my humble submission, power under section 319 of the Criminal Procedure Code should not be exercised at the cost of de novo trial, not proper.
If 319 is allowed, it will be a de novo trial.
Yes, that's what the Appeals Court has said, not myself. What the Appeals Court has said in my humble submission, that is the judgment AIR 2000.
De novo trial qua the persons who are already facing trial, or it will be a separate trial so far as you are concerned.
No, my lord, in my humble submission, the Appeals Court has said in 2000 Supreme Court that if all the witnesses were examined, then in my humble submission, at the belated stage, the power under section 319 of the Criminal Procedure Code.
I have understood that. I just want to know that if a petition under section 319 is allowed and if additional persons are made to face the trial, then under such circumstances there will be a de novo trial.
Yes. Why?
Okay, we will see which judgment are you citing.
Yes, 2000 Supreme Court. Why?
Kindly give the citation. You complete your formulation of your point. I will hear you.
Yes. AIR 2000 Supreme Court, page 1127,
Para number,
para number 11, 12 of this judgment.
party name,
And party's name is Michael Machado and others. Appellant versus Central Bureau of Investigation
that's right.
and others. Respondent.
What is the fourth point?
Minus,
Other point?
these are the only 4 points which we are raising for minus kindness.
Kindly come one by one. First point.
First point. Now, the first point is in my humble submission.
Now let us see the impugned order. What is the material which has come up against you, which is not there in the case diary, or it is there in the case diary?
Minus, it is in the diary itself.
Okay, let us
Because
see.
of the reasons, the petitioners were named in the fire.
Let us see, please. Let us read the impugned order.
Kindly see, Minus. Kindly see. Page number 29, Lordship may kindly peruse.
Page number 28. You read the full text.
And one thing I want to point out for Lordship kind consideration. While hearing this petition by your Lordships, this on the court, Lordship had directed me to file the copy of the evidence of the witnesses examined in this case, and in view of the order passed by the Honorable Court, we have filed the evidence of the witnesses examined in a section by the trial court, along with my supplementary affidavit. Now, Lordship may kindly peruse the impugned order. Lordship want to see that. That is at page 29.
28.
Yes, ma'am.
28.
Yes. May I read it?
Yes, yes.
Kindly see, madam. Today, case record is fixed for passing order on a petition dated 11th January 2022, filed on behalf of the informant, not a state. The state is the party prosecuting the petitioners. Under section 319 CRPC, copy of the petition has also been served by defense side on 4th February 2022. Heard both sides, learned counsel appearing on behalf of the petitioner submitted that the FIR was instituted against 8 accused persons, but after completion of investigation, 5 of this case submitted charge sheet on 31st May 2017 showing lack of evidence against 3 accused persons, namely Munna Saul, Sasi Saul, Sikandar Saul, and alias Suraj Saul, the petitioner's hearing. It is further submitted that during trial of the witnesses have supported the involvement of these 3 accused persons in the occurrence, and as such, there is sufficient materials available on record for issuing the process against these 3 accused persons under section 319 CRPC. Learned APP on behalf of the state also supported the argument of the learned counsel appearing on behalf of the informant. Learned counsel appearing on behalf of defense side opposed the prayer. Peruse the record, it appears that total 10 prosecution witnesses have been examined up till now. Out of PW2, 3, 8 are doctors, PW9 is the investigating officer, PW6 is the informant of this case, and PW6 has said in his examination in chief before the court that on 13th April 2016 at about 8 to 8:30 am, he was at his new house. The accused persons, namely Munesar Saul, Munna Saul, Badri Saul, Nandlal Saul, Sikandar Saul petition number 3, Sasi Saul petition number 2, Munni Devi petition number Munna Saul is petition number 1 minus. Munni Devi and Meena Devi armed with Lati, Danta, Rod and Sabal came there and they assaulted his father with intention to kill him, due to which his father sustained head injury and blood came out. So, from perusal of the evidence of this witness, it appears that this witness has supported the involvement of accused persons, namely Munna Saul, petition number 1, Sasi Saul, petition number 2, Sikandar Saul, petition number 3 in the occurrence. Now, from perusal of evidence of PW1, Sita Ram Singh, PW4, Arun Kumar Yadav, PW5, Dulari Devi, PW7, Mundari Devi, and we have obtained Angira Devi, it appears that all the witnesses have taken the name of these three accused persons and they have supported the involvement of these three accused persons in commission of the crime. In the case of Rao Suraj versus State of Jharkhand, 2009, Volume 2 SCC, page 696, the Honorable Court settled the legal position that even if a person had not been charged sitting, he may come within the purview of description of such person as contained in section 319 CRPC. So after going through the entire evidence available on record, I find prima facie sufficient materials to proceed against the accused persons, namely Munna Sahu, Sasi Sahu, Sikandar Sahu. Accordingly, petition dated such and such is hereby now proceed directed to summon to the accused persons, namely Munna Sahu, Sasi Sahu, and Sikandar Sahu, put up this case for appearance of the accused. This is the order.
That's Is it final form or charge sheet?
Yes, kindly see the final form. Annex 2, madam. I have given the Xerox copy of the certified copy, and madam, we have given the type copy also, page 21. So I pray before this one court to kindly peruse the type copy, madam, page 26.
Yes.
Lordship got it. May I read it?
Yes, read
Yes,
it.
kindly see.
Ye can't.
यह कान वादी जमुना प्रसाद यादव पेशरान मुन्ना गो सो हजारीबाग के फर्द बयान के आधार पर प्राथमिक अभियुक्त मुनीश्वर साहू एवं 7 अन्य के विरुद्ध नाजायज मजमा बनाकर मारपीट करने जिससे इनके पिता की मृत्यु हो गया के आरोप में अंकित कराया गया है। अब तक के अनुसंधान घटनास्थल के निरीक्षण, गवाहों के बयान, पर्यवेक्षण शोभा देवी के आवेदन की जांच एवं अंतिम प्रगति प्रतिवेदन के यह कांड 147, 148, 149, 448, 452, 323, 325, 307, 302 IPC के अंतर्गत अभियुक्त बद्री साहू, नंदलाल साहू, मुनीश्वर साहू, मीना देवी, मुन्नी देवी के विरुद्ध सत्य एवं प्राय अभियुक्त मुन्ना साहू पिटिशनर नंबर 1, शशि साहू पिटिशनर नंबर 2, सिकंदर साहू पिटिशनर नंबर 3 और सूरज साहू के विरुद्ध साक्ष्य की कमी पाया गया है। इस कांड की प्राथमिक अभियुक्त बद्री साहू, नंदलाल साहू, मुनीश्वर साहू के विरुद्ध अनुसंधान पूर्ण कर आरोप पत्र संख्या सच एंड सच 11/7/16 समर्पित किया जा चुका है। कांड का अनुसंधान प्रत्येक बिंदु पर पूर्ण है। अतः आदेशानुसार इस कांड में प्राथमिक भारतीय दंड विधान के अंतर्गत मुन्ना साहू, शशि साहू, सिकंदर साहू, सूरज साहू के विरुद्ध साक्ष्य कमी बताते हुए प्राथमिक अभियुक्त मीना देवी, मुन्नी देवी, पति बद्री साहू दोनों को पूरक आरोप पर संख्या सच समाप्त करता हूँ ताकि न्यायिक हिरासत में विचार हो सके। दिस इज द फाइनल।
So, final report is conclusive. Final report is conclusive.
Not conclusive. My submission
Has any evidence come during trial or not? And what is the nature of evidence which has come during trial?
I am coming to that. I will come to that. First, my submission.
Because in 319, we have to see the evidence which has come during trial.
That is true. Now, in my humble submission, Lordship asked me to place the transcript.
I've seen it.
Final report, so we have read it. I am not saying it is conclusive.
That's
I've never said it. My submission for my Lord's kind consideration is that after the charge sheet was submitted, the learned court below did not take cognizance against this petitioner.
That's right.
And the cognizance was taken other accused persons, and they were facing trial.
That's right.
Now, when they were facing trial, the witnesses were examined. Now, in my humble submission, we have annexed the copy of the evidence of the witnesses who have been examined. Or if you want to see that, then
No, I
will-
just want to know, is it your case that the witnesses did not depose against you?
No. Only vague and omnibus allegation has been given by the witnesses in the court. And in my humble submission, on the basis of that vague and omnibus allegation which has been given by the witnesses, in my humble submission, from the evidence of those witnesses, in my humble submission, that this petitioner may not be convicted by the learned court. And the appeals court has said that the evidence must be to that effect that if the court consider it that they may be convicted, only then the exercise of power under section 319 can be exercised. On this, there is a judgment of the appeals court.
34 is also there.
Minus
120B, 34, these sections are there.
120,
120B and 34.
conspiracy,
34.
common intention. So, Manoj, in this case, Lordship may kindly see.
Let us see. You say that where is your name in the evidence? You just read the evidence.
Hello?
You just read the evidence. You say that there is no material against you. Let us have a look at it.
Material, Manoj, in my humble submission, the petitioners are named in the
Kindly
FIR.
read it. Kindly read it. Let's have a look at it.
No, Lordship, look at it. But
We cannot decide a 319 petition without reading the evidence which has come.
Right.
Isn't it? Kindly read it.
the Lordship, read it, Manoj, kindly see. First, Manoj, we have filed along with my supplementary affidavit.
Yes, I have seen the supplementary affidavit you come. What is the name of this petitioner? Munna Sao,
Munna Sao,
Shashi Sao,
Sikandar Sao.
and Sikandar Sao.
My. Kindly see, Manoj, an extra 4 series of my supplementary affidavit. Lordship got it, Manoj? May I place it? Page number 5.
You just read the relevant portion of the deposition.
Yes, only I will read the relevant portion. And the date also, when these witnesses were examined. Minors, para 1, if Lordship may kindly see, of the evidence of this witness PW1. घटना लगभग 3.25 साल पहले की है। उस समय मैं अपने घर पर था। लगभग 8 से 8:30 बजे सुबह हल्ला सुने। हल्ला पर मैं दौड़कर मुन्ना मक्को के घर गया। वहाँ देखे कि भुवनेश्वर साहू, नंदलाल साहू, बद्री साहू, मुन्ना साहू पिटिशनर 1, सिकंदर साहू पिटिशन नंबर 3 एंड शशि साहू पिटिशन नंबर 2, बद्री साहू की पत्नी, नंदलाल साहू की पत्नी, ये सभी मुन्ना महतो व मुन्ना महतो की पुतों को लाठी डंडा रड से मारपीट कर रहा था। मुन्ना महतो का सर फट गया था और वह गंभीर रूप से घायल हो गया था और उसकी बड़ी पुतों एवं मंझली पुतों के माथा फटा हुआ था। मुन्ना महतो की पत्नी का हाथ टूट गया था और कंधा भी टूट गया था। जमुना गोप अंगली टूट कर लटक गया था। गांव के कुछ लोग और जुटे तो झगड़ा छुड़ाए और मुन्ना गोप की पुतों तथा मुन्ना गोप की पत्नी को लेकर बड़ी और मंडली अस्पताल गए। फिर वहाँ प्राथमिक उपचार के बाद बेहतर इलाज के लिए गाड़ी पर बाद में सुना कि मुन्ना गोप सदर अस्पताल जाने के क्रम में ही रास्ते में ही मर गया। दिस इज द चीट पॉइंट। This witness in my humble submission in the charge sheet is witness number 4. Now,
You continue your argument. Don't stop.
no.
I'm used to multitasking. हम सुनने के साथ पढ़ सकते हैं.
नहीं, उसमें तो कोई दिक्कत नहीं है। उसमें हम लोग we know it, but I thought that since my lord is perusing the file, so I thought that Lordship will direct me, then I will begin it. So my submission is that in my humble submission, Lordship has seen the evidence of PW1. What he has said, vague and anonymous allegation he has given in his evidence. He has not said that what overt act he had done. General allegation. Can on the basis of the general allegation without attributing the specific overt act, I know there can be conviction.
That's right.
In my humble submission, there are several judgments of the Appeals Court on this point. In my humble submission, there cannot be conviction unless my lords, the witnesses examined during trial makes any evidence, says any evidence with regard to the specific overt act on which assault made by the person, my lords, that was fatal to cause death. Nothing has been said by this witness. Similarly, in my humble submission, the witness number 2, if Lordship may kindly see, that is Manitosh Kumar, doctor.
No, you don't read the doctor. Doctor may not be relevant.
There are 3 doctors.
Doctors may not be relevant, isn't it?
That is true.
You just come to page number 13, PW4. PW4.
PW4. PW4 minus page number 30. Kindly see.
Similar allegation.
Similar type of evidence has been given by all the witnesses in my humble submission. No specific role has been said by any witnesses with regard to these persons. And during investigation, the police had found that these petitioners were not there at the time of place of occurrence, and due to this, the police had submitted final report against them.
Police found that they were not there at the place of occurrence.
Yes, that has been found by the police during investigation. Hello, they were a student, they had gone to school, colleges, and all family members have been made accused in this case. Lordship had also called for the diary for perusing that whether on what basis the police has submitted final report.
That's
I can produce it if Lordship will so direct me to produce the diary also.
It is there. We are here.
Hello?
The diary is here.
Yes, yes, diary is here. Diary was also called for. So similarly, the evidence of PW4 also matters. Kindly see values para 1 I am reading. 13/4/16 की है 8-9 बजे सुबह की है। उस समय मैं अपने घर पर था, जहाँ देखे कि मुन्ना गुप्त, उसकी पत्नी, उसकी पुतो, ये लोग अपने घर के पास बैठा हुआ था। उसी समय बद्री साहब, मुन्ना साहब, नंदलाल साहब, मुनेश्वर साहब, सिकंदर साहब, PW पिटिशन नंबर 3, then वालों बद्री साहब की पत्नी सो एंड सो आए और उन लोगों पर हमला कर दिया, लाठी डंडा रॉड से हमला कर दिया। मुन्ना गुप्त की पत्नी और उसकी पुतो सभी को घायल हो गए, हम लोग भी सभी घायल हो गए, घायल को सरकारी अस्पताल ले गए। So Lordship had seen the similar evidence has been given by this witness also. No specific role played by this person has been mentioned in the evidence. Nothing. Then Lordship may kindly see PW5 is also the charge sheet witness number 3 in the charge sheet. May I place it, madam? Kindly see, madam. I am placing the evidence of Julari Devi. घटना पौने 4 साल पहले की है, चैत महीना के दिन बुधवार की है। घटना लगभग 8 बजे की है। उस समय मैं अपने सास ससुर अन्य परिवार के साथ घर पर थी। मेरे ससुर मुन्ना यादव और सास अंगिरा देवी घर में बैठे थे और मैं और मेरी गोतनी अंगिरा देवी गोईठा ठोक रहे थे। उसी समय नंदलाल साहू, बद्री साहू, मुन्ना साहू, पिटिशन नंबर 1, देन शशि साहू, पिटिशन नंबर 3, सिकंदर साहू, पिटिशन नंबर 2, मुन्नी देवी, मीना देवी सभी लोग लाठी डंडा कपल लेकर आए और हमारे घर तोड़ने लगे। मेरे सास ससुर मना किए। इसके बाद मेरे ससुर को मारकर माथा फाड़ दिया, मेरे ससुर को मारकर गिरा दिया और बेहोश कर दिया। सास को भी मारकर कंधा और हाथ तोड़ दिया। मेरी पुत्री को भी माथा फाड़ दिया। मेरे देवर यमुना यादव को भी मारकर उसका कलाई तोड़ दिया। So Lordship had seen that Nothing has been said with regard to any overtax against this person, vague and omnibus allegation. Now, on the basis of the vague and omnibus allegation of the evidence of the prosecution witnesses in my humble submission, repeatedly the appeals court and the honorable court has said in several judgments in my humble submission there cannot be conviction unless a specific role played by the accused person is said by the witnesses. Similar is the evidence of the other witnesses also, if Lordship we kindly see, PW6. He is the charge sheet witness number 1, Yamuna Prasad Yadav. घटना का दिन 13/4/16 की 8 से 8:30 बजे की है। उस समय हम लोग अपने नए घर पर थे, जो मेरा नया घर सर्किट सीट का एक कमरे का है। यहाँ मेरी माँ सुंदरी देवी, पिताजी मुन्ना वो घर के बाहर बैठे हुए थे, मैं भी वहाँ पर था और हम लोग आपस में बात कर रहे थे और बगल में हमारी दोनों भाभी दुलारी देवी गोठा ठोक रही थी। वहीं पर अचानक हमारे गांव के ही मनुष्य साहु मुन्ना साहु पिटिशन नंबर 1, बद्री साहु, नंदलाल साहु, सिकंदर साहु पिटिशन नंबर 3 एवं शशि साहु पिटिशन नंबर 2, मुन्नी देवी, मीना देवी अपने अपने हाथ में लाठी डंडा रॉड खबर लिए हुए आए और हमारे पिताजी पर अचानक जान मारने के लिए से सभी अभियुक्तों ने हमला कर दिया। उससे हमारे पिताजी का माथा फट गया और खून बहने लगा। इसके बाद मेरी माँ पिताजी को बचाने गई तो मेरी माँ के ऊपर भी सभी अभियुक्तों ने हमला कर दिया, जिससे मेरी माँ का हाथ टूट गया और गले की हंसुई टूट गई। उसके बाद जब हम लोग मेरी दोनों भाई घटनास्थल पर मौजूद थे, बताने गए, सभी अभियुक्तों ने मिलकर हम लोगों को भी मार कर बुरी तरह से जख्मी कर दिया, जिससे मेरी दोनों भाभी के माथा में गंभीर रूप से जख्म हो गया और मेरा बाएं हाथ का रिंग फिंगर टूट गया। सभी उसके साथ मिलकर बोल रहा था कि सभी लोगों को मार दो ताकि जमीन पर कोई नहीं आएगा और रोने वाला कोई नहीं रहेगा। हम लोगों के बीच जमीन विवाद का मुकदमा चल रहा है, लैंड डिस्प्यूट चल रहा है। वे लोग दबाव बना रहे थे कि सभी केस उठा लो। इसी रंजिश को लेकर सभी अभियुक्तों ने जान मारने की नीयत से हम लोगों को पूरी तरह से मारकर जख्मी कर दिया। घटना के दौरान हम लोग हल्ला किए और गाँव से गाँव के अन्य लोग आए और हम लोगों को जान दिया। दिस इज व्हाट दिस विटनेस हैज सेड इन माय हम्बल सबमिशन। उसके बाद पारा 18 में कहते हैं अभियुक्तों के साथ जमीन का विवाद घटना के लगभग 1 साल पहले से चल रहा था। हम लोग चाहते हैं कि अभियुक्त लोग उस जमीन पर दावा छोड़ दें और गवाह स्वतः कहते हैं कि जमीन हमारी। उसके बाद पारा पुलिस केस में का अनुसंधान किया है। हम नहीं जानते कि पुलिस ने 3 मुद्दालों का नाम हटा दिया है। हम नहीं जानते हैं कि नाम हटा दिया है। उसके बाद फिर मेरे पिताजी को लाठी से नहीं रॉड से लगा था। मेरे पिताजी को 2 बार रॉड से लगा। उसके बाद 8 आदमी मिलकर लाठी से गिरने के बाद अनगिनत लाठी मारा ताकि लोगों को भी अनगिनत लाठी डंडा रॉड से लगा। उसके बाद खून से लथपथ हो गए और 42 में सदर अस्पताल के पुरुष वार्ड में भर्ती था। बेड नंबर सच में याद नहीं। अस्पताल में मैं 1 दिन भर्ती रहा क्योंकि अगले दिन पिताजी के लिए संस्कार था। Then I was PW7 and witness number 6 in the charge sheet, सुंदरी देवी। यह घटना 6/2020 होने पर 4 साल हो जाएगा। घटना सवेरे 8 बजे घटित हुई है। घटना के वक्त अपने पति मुन्ना यादव के साथ घर के बाहर बैठी हुई थी और मेरी पुतो मंगीरा देवी और दुलारी देवी बगल में गोइठा ठोक रही थी। उसी समय मुन्ना साहु पिटिशन नंबर 1, मुन्ना साहु सुंदरी देवी, नंदलाल साहु, सिकंदर साहु, शशि साहु, मुन्नी देवी और मीना देवी हाथ में लाठी डंडा रॉड तबर लेकर आए और मेरे पति को मारने लगे। मेरे पति का माथा फट गया और खून बहने लगा। मैं बचाने गई तो मुझे भी मारा, जिससे मेरा दाहिना हाथ टूट गया और वहाँ टूट गया। दाहिना हाथ में कलाई के ऊपर।
So investigating officer ने एलिबी का प्ली लेकर उनका एक्यूटल कर दिया एक तरह से।
जी
आप जब देखिए पेज नंबर 27 में
27
पेज नंबर 27 नहीं, पेज नंबर 26 द एविडेंस ऑफ द आईओ।
yes.
स्कूल में जाके देखे वो वहां पर थे, एक का फोन नंबर लाके देखा कि वो कहीं और थे एंड आई विटनेसेस वर डिसबिलीव्ड एंड दे वर नॉट चार्जशीटेड। All the eyewitnesses have stated that they were present. And then he went to the school to find out whether one of them was present in the school or not. Then he found that yes, he was present in the school.
School. Kindly see on which paragraph law is
You just see page number 26.
Yeah, 27, 26.
26.
Yes, madam, 26.
26, para number 11, 16, 17, 18.
I'm reading, madam.
Read it, please.
Kindly see. अब तक के मुसलमान घटना तक निरीक्षण वादी और गवाहों का बयान पोस्टमार्टम रिपोर्ट बड़ी पदाधिकारी क्वेश्चन से खान अंतर्गत अभियुक्त बद्री साहब मुनेश्वर साहब नंदलाल साहब के विरुद्ध अनुसंधान पूर्ण पाकर आरोप पत्र संख्या 11/7/16 समर्पित किया तथा शेष अभियुक्त मुन्ना साहब शशि साहब सिकंदर साहब मीना देवी और मुन्नी देवी के विरुद्ध पूर्वक अनुसंधान जारी रखा। यह आरोप पत्र संख्या 176/16 मेरे कहने पर थाना के मुंशी प्रकाश शिवराम के द्वारा लिखा गया, जिस पर मेरा हस्ताक्षर इसे मैं पहचानता हूँ। आरोप पत्र को 15 अंकित किया गया। वादी के फर्द बयान पर पुस्तांकन मेरे लिखावट हस्ताक्षर में है, जिसे मैं पहचानता हूँ, अंकित किया गया। सारी प्राथमिक कंप्यूटर सर्किट जिस पर मेरा हस्ताक्षर इसे मैं पहचानता हूँ। पूरक अनुसंधान के क्रम में 20/7/16 को साक्षी प्रेम कुमार सुंदरम सुषमा सुंदरम शोभा देवी रामधनी यादव सम्मी देवी गौरी देवी का बयान लिया। इसके बाद अनुसंधान क्रम में प्राथमिक अभियुक्त मुन्ना साहब का मोबाइल नंबर इतना का 11/4/16 से दिनांक इतना तक का तकनीकी सेल से सीडीआर निकालने हेतु पुलिस अधीक्षक खिलाड़ीबाग को भेजा। शशि कुमार साहू की उपस्थिति के संबंध में एक आवेदन थाना व्यापक संख्या इतना 11/8/16 के माध्यम से प्राचार्य डीएवी स्कूल बरी को भेजा गया। दिनांक 12/8/16 को डीएवी पब्लिक स्कूल बरी का पत्रांक कितना 12/8/16 प्राप्त हुआ, जिसमें अंकित है कि शशि कुमार का रोल नंबर इतना संख्या है संख्या 2362 दिनांक 13/4/16 को सुबह 7:15 से 1:20 तक विद्यालय में उपस्थित थे। दिनांक 15/9/16 को मोबाइल नंबर 7 सीडीआर ज्ञात हुआ, जिसे तुरंत अनुसंधान के 12:45 में अंकित किया गया। दिनांक 25/4/17 को अभियुक्त मीना देवी मुन्नी देवी का आत्मवर्तन पर्ची प्राप्त हुआ। उसके बाद दिनांक 15/5/17 को जख्मी यमुना यादव मुन्ना देवी प्राप्त किया। उसके बाद प्राप्त हुआ। अंतिम प्रतिबंध प्राप्त हुआ। दिनांक हजारीबाग कार्यालय संख्या इतना प्राप्त हुआ। अब तक अनुसंधान स्थल में बच्चों के वादी एवं गवाहों का बयान पोस्टमार्टम
आप हमको बताइए। You see, the eyewitnesses of the occurrence are saying that they were present. They were present amongst the assailant.
Yes.
And the IU goes for investigation and finds out from the school register about his presence over there.
In school.
And then in school, and he also finds out the CDR report and says that they were not there. And these witnesses have stated the presence of all three of you at the time of occurrence.
Yes.
319 cannot be invoked.
In my humble submission, Malus, the principle which has been laid down by the court, which I have referred for my kind consideration, if Lordship may go through those judgments in my
I will go through, don't worry.
and Lordship may find that what are the principle to pass order under section 319 of the Criminal Procedure Code. Now, if Lordship so direct me, then I can place those judgments for my Lord's
I have noted all the judgments that you have cited.
Yes.
I will certainly go through it. But you also go through one judgment. Maybe that has been placed on record by the opposite party, I don't know.
2009.
2021.
2021 I have referred, my Lords.
You have referred?
Yes, yes. I have just now referred 2021 Supreme Court. My Lords, in my humble submission, I have also placed that judgment for my Lord's kind.
So that will...
Sartaj Singh versus State of Haryana, 2021.
Yes.
And thereafter, my Lords, the constitutional bench judgment also. Sukhpal Singh Khera versus State of Punjab. All the answers are there, my Lords, in these two judgments. At what stage the 319 can be invoked? That has been answered. And certain guidelines has been given by the constitutional bench. In page 43, the Supal Singh Khera's judgment, the guidelines are there.
Yes, can you read it? Can you read it?
Supal Singh Khera, Constitution.
हरदीप सिंह का जो केस है 2014 का
वो सब कंसिडर हुआ है इन सरताज
ये
सिंह।
तो नया गाइडलाइन आया है तो हम लोग गाइडलाइन से गाइडेड होंगे unless the guideline is modified.
That
Yes.
is true. Well,
Then
but
yes.
the principle values.
Just a moment. I am hearing you for almost an hour now. Right? Let us. I have understood. I have understood your case. Fully understood. Yes.
What are the guidelines that the competent court must follow while exercising power under Section 319 CRPC? 1. If the competent court finds evidence or if application under Section 319 of CRPC is filed regarding involvement of any other person in committing the offence based on evidence recorded at any stage in the trial before passing of the order of acquittal or sentence, it shall pause the trial at that stage. The court shall thereupon first decide the need or otherwise to summon the additional accused and pass orders thereon. If the decision of the court is to exercise the power under Section 319 of CRPC and summon the accused, such summoning order shall be passed before proceeding further with the trial in the main case. If the summoning order of additional accused is passed, depending on the stage at which it is passed, the court shall also apply its mind to the fact as to whether such summoned accused is to be tried along with other accused or separately. If the decision is for joint trial, the first trial shall be commenced only after securing the presence of summoned accused. If the decision is that the summoned accused can be tried separately, on such order being made, there will be no impediment for the court to continue and conclude the trial against the accused who were being proceeded with. In the present case, the trial has been split up.
Split.
If the proceeding paused, as in 1, above is in the case where the accused who were tried are to be acquitted and the decision is that the summoned accused can be tried afresh separately, there will be no impediment to pass the judgment of acquittal in the main case. If the power is not invoked or exercised in the main trial till its conclusion and if there is a split up bifurcated case, the power under Section 319 of CRPC can be invoked or exercised only if there is evidence to that effect pointing to the involvement of the additional accused to be summoned in the split up bifurcated trial. If after arguments are heard and the case is reserved for judgment, the occasion arises for the court to invoke and exercise the power under Section 319 of CRPC, the appropriate course for the court is to set it down for re-hearing. On setting it down for re-hearing, the above laid down procedures to decide about summoning, holding of joint trial or otherwise shall be decided and proceeded with accordingly. Even in such a case, at that stage, if the decision is to summon additional accused and hold a joint trial, the trial shall be conducted afresh and de novo proceeding be held. If in that circumstance the decision is to hold a separate trial in a case of summoned accused as indicated earlier, the main case may be decided by pronouncing the conviction and sentence and then proceed afresh against summoned accused. In a case of acquittal, the order shall be passed to that effect in the main case and then proceed afresh against summoned accused.
Here the trial has been split.
Split.
And 82 process has also been issued.
Now, my lords, in another case, 2023 volume 1 SCC 289. Now the another judgment, my lords, 2021 judgment, Sartaj Singh versus State of Haryana. In this case also, my lords, several points were laid down by the court and the court has held that only on the basis of examination in chief the summons can be issued. The court cannot wait for the cross-examination of the witnesses.
Even cross-examination is not required.
Not required.
And here is a case where
From the very beginning, from the FIR itself, there was allegation.
They are
named in the FIR.
but
From
police
the
has
very
given a clean chit by saying that they were.
That has also been referred in the 2021 judgment. Why this necessitated 319 powers, paragraph 19. The court is the sole repository of justice and a duty is cast upon it to uphold the rule of law. And
Para
therefore,
19 of this Sukhpal Singh Kharias.
नहीं ये Sartaj Singh case.
Sartaj. Para 19. Page would be?
Because
Page number
paging is not there.
6.4, then 7, then 8.
6.1.3 में फिर paragraphing है 12, 13, 14. Then
But
next
अजीब
page.
तरह का paragraphing.
Paragraphing is quite.
आप जरा बताएंगे इसको देखो.
हाँ.
This is Sartaj Singh.
No.
Yes.
Paragraph 9.
Yes. Yes, please.
The court is the sole repository of justice and a duty is cast upon it to uphold the rule of law. And therefore, it will be inappropriate to deny the existence of such powers with the courts in our criminal justice system, power under 390, where it is not uncommon that the real accused at times get away by manipulating the investigating and or the prosecuting agency. The desire to avoid trial is so strong that an accused makes effort at times to get himself absolved even at the stage of investigation or inquiry, even though he may be connected with the commission of offence. This is the principle why the 319 is there with us. And several questions were also framed 2 pages earlier, Milords.
I think that would be sufficient. We don't need anything more. You have to say anything in response? You can refer to 1 or 2 paragraphs of the judgments that you have cited, which clinches the issue. Then I will just pass on.
Hardeep Singh has also been considered in Sartaj Singh case.
He is in trouble. Let him respond. Yes, Patayas.
Whereas my submission is.
No, I have heard your submission. You just refer to the judgment.
I should refer the judgment.
Yes, because you say that the issue is covered by the judgments. So, which all judgment you want to rely upon, you place the judgment.
Okay.
Yes.
Well, the judgment which my learned friend has relied. Well, in my humble submission.
No, first you rely upon your judgment. We will see his judgment later.
I am first relying on my judgment which I have referred to.
Yes, which you have referred. Which judgment you want to place first?
Well, the points which I have formulated, Lordship have taken note of that.
I have not.
Now, the first judgment in my humble submission, the guideline judgment of the Supreme Court, 1990 Supreme Court, which I have referred.
Okay, can you place that judgment?
1990 Supreme Court, which I have referred for Lordship guideline.
Yes.
And paragraph 14, 30 and 33.
Kindly read it.
Well, before going to that judgment, well, first I will place before this report, what is the provision of law section 390?
No, we have read it. We have read it. I have read it while you were arguing. I have gone through that judgment. What do you want to point out?
What I want to point out, Lordship may permit me, then I will point
Okay.
it, otherwise not.
Chaliye.
Because everything
एक बार
we
और
know.
पढ़ते हैं. Every time we
Then
read, we have new
everything,
lines.
every day we read section 439, 438, article 220. Every
You
day
read.
we are
What is
reading
it?
because
What
of
is
the
it
report.
that you want to point out?
So, Lordship may kindly peruse, thereafter Lordship may interpret in my humble submission in the light of the judgment of that. So, kindly see section 319 of the CRPC. May I place it, madam? Power to proceed against other person appearing to be guilty of offence, where in course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused this is very relevant in my not being the accused, has committed any offence for which such person could be tried together with the accused, the court may proceed against such person for the offence which he appears to have committed. So what I am submitting for Lordship kind consideration, any person not being the accused, that has been interpreted by the Apex Court in my humble submission in 1990 Supreme Court, thereafter there was Hardeep Singh case, constitution based judgment, and thereafter several judgments in my humble submission. This has been interpreted. What is the meaning of the word? Not any person not being the accused. First, minutes I will refer in this regard the 1990 Supreme Court, paragraph 14, 30 and 33 minutes. I have given the Xerox copy of the judgment. Kindly peruse minutes, paragraph 14 of the judgment of 90 Supreme Court. Thereafter, I will place the other judgment of the Apex Court on this point. The crucial words in the section are any person not being the accused, which I have just now placed before the Honorable Court, mentioned in section 319 of the CRPC. Section any person not being the accused. This section empowers the court to proceed against person not being the accused, appearing to be guilty of offence. Subsection 1 and 2 of this section provide for a situation when a court hearing a case against certain accused person finds from the evidence that some person or person other than the accused before it is or are also connected in this very offence or any connected offence, and it empowers the court to proceed against such person or person for the offence which he or they appear to have committed and issue process for the purposes. It provides that the cognition against newly added accused is deemed to have been taken in the same manner in which cognition was first taken of the offence against earlier accused. It naturally deals with the matter arising from the course of proceeding already initiated. The scope of section is wide enough to include case instituted on private complaint. So, my lords, in my humble submission in this judgment, the Apex Court has held and interpreted what is the meaning of the word not being the person not being the accused appearing in the section 319 of the CRPC. So, in the light of the judgment, my submission for my lord's kind consideration is that Lordship had seen that this petition...
Accused before it means what? At the stage of trial, accused before it means what? At the stage of trial, if a person is accused before the court, what does that mean?
Person not being the accused, appearing to not be a person...
Other than the accused before it. We will read the accused word term accused before it.
Before it.
Before it means what?
Before
the trial court, a person who is not facing the trial is not an accused before the court. सर आप इतना सीनियर हो गए, ऐसा बहस ना 319 पर आप सारे जजमेंट्स दिखाए, हम भी एक जजमेंट किए हैं जो आप देखे ही नहीं होंगे.
नहीं देखे.
हाँ नहीं, आप ये बात बोलिए कि आप देखना नहीं, अब इतना सुप्रीम कोर्ट का जजमेंट्स आ गया तो मेरा जजमेंट इज वैल्यूलेस, इसलिए उसका कोई मतलब नहीं. So these aspects, whatever you are saying, has been taken care of. Every aspect has been taken care of in that judgment. वो uphold भी हो गया.
I know that Lordship always give judgment after taking care of all the judgments referred by.
So therefore, you see, you.
May I pray one thing? In my humble submission, I will be very much obliged that if the judgment given by your...
No, I will not. I am not here to advise you and ask you. Those judgments are all reported. You don't see the judgments of your court and you cite judgments from all other high courts except the judgments of your own court. This is
May-
the
may- may-
this is
may-
the
may-
hard reality of
may-
this
may-
High Court.
May I pray one thing?
That here the councils, they do not cite their own judgments.
May I pray one thing? Subject to my Lord's kind consideration in my humble submission. If Lordship has already disclosed, your Lordship has taken view on this point under section 319 of the Criminal Procedure Code, and if my case does not fall under that purview, then in my humble submission, my Lord, I will not praise this petition. I will be the last person to praise the petition before the Supreme Court.
I am not inclined. I am making my mind very clear to you.
No, that is true, my Lord. In my humble submission, I am obliged that Lordship will disclose your mind, my Lord.
Because
But
I know that these any orders, howsoever I say that it will not affect the trial, वो कहीं ना कहीं से घुस जाएगा trial के mind में. अब कितना भी कुछ बोल दें, I know.
What submission we are making from
So
my
you
Lord?
withdraw it. Let's finish it off here only.
No, my
I
Lord,
will not say anything more.
in my humble submission.
After hearing for I think 1.5 hours now,
No, what I'm
there is no
submitting-
problem. I don't want anybody to be prejudiced by any observation. It's a murder trial. 120B, 34, everything is there, motive is there, eyewitnesses are saying, the injured witnesses are saying, and your police officer gives an alibi. How serious it is.
My Lord, the point.
He gives an alibi and then he does not find charge sheet. An alibi on the basis of CDR report. हम अपने घर में फोन छोड़ के आएंगे तो CDR रिपोर्ट क्या बताएगा?
Point.
Just tell me. हम अपने घर में फोन छोड़ के आएंगे तो CDR रिपोर्ट क्या बताएगा?
ठीक है, जो पॉइंट हम बहस कर रहे हैं, my Lord.
हम नहीं आप you can't have it both ways.
Well,
You can't have it both ways. If you
No,
want to withdraw, I will not have any objection to it.
my Lord, in my humble submission, we are very much obliged that Lordship will disclose views in my humble submission. But one thing, for the satisfaction of my client in my
No, you can't. We are not here to satisfy anybody, right? We are here to satisfy the law only. If you want to argue, I will pass a very reasoned order. You don't worry about it. Discussing all the evidences
No,
on
my
it.
Lord, it is not, we know it and we have seen several times. I am not saying that Lordship will not pass reasoned order. Lordship will pass. But my Lord, in my humble submission, my Lord, whatever Lordship will pass, my Lord, we will abide by that. But my submission, only one submission, my Lord. May I pray for my kind consideration? My Lord, the judgments which we are relying before this criminal court on each point, then may I pray, my Lord, that if Lordship put this matter tomorrow, I will seek instruction from my client. I will straightway withdraw without arguing the case tomorrow. Tomorrow, make it
Learned counsel for the
partner.
parties are present. After hearing the learned counsel for the parties, when this court has disclosed the mind that this court is not inclined to grant the relief as prayed for by the petitioner, the learned senior counsel for the petitioner submits that the matter be posted tomorrow so that he may seek instructions from his client with regard to withdrawal of the present
Right.
case.
Tomorrow. All right.
आपका
Obliged.
क्लाइंट सुन रहा होगा उसको YouTube
ठीक
में
है,
सुना दीजिए.
obliged, my Lord.
What do you want? You never mentioned it. No, you see, I am a very slow court. Right? I take my own time to understand this. I am a very, very slow court. I take my own time.
I totally blame it. They give time to everybody. That's a little bit.
I am never in a hurry.
I know that. But
अगला केस को करने के लिए ये केस नहीं खराब कर सकते हैं.
If actions are submitted,
कल.
if we post it for
Tomorrow.
Section 46.
What is NI Act?
NI Act, surrender.
You have to deposit certain amount,
Wait,
20%.
Out of 1,50,000, I have deposited 30,000. I have the counterfeit receipt.
Okay.
30,000 I have given the compensation.
Deposited where?
The learned appellate court. That's the count receipt.
Okay, fine. So remaining 20%, total 20% you have to deposit. I will deduct that amount and 20% you have to deposit.
Out of the total remaining.
Out of the total compensation amount.
Compensation is 1,50,000.
वो आपको जमा करना पड़ेगा. Other side has appeared.
He is there. His name is reflecting on the board.
आप लोग को compromise नहीं करना है. You want to fight.
ड्यूरिंग अपील लड़ से 20% इन्होंने डिपॉजिट किया है.
अच्छा.
अभी तो
20% कर ही दिया है.
अभी नहीं अपील कोर्ट पे किया.
हाँ, ठीक है. अब ठीक है, छोड़िए ना. कितना 1 लाख 2 लाख रुपए के लिए कितना परेशान करिए.
पुअर लेडी हो.
पुअर को पुअर मत बनाइए. और आपको बहस करना है, फाइनली सुन लेंगे. LCR आ गया?
नहीं, कुछ एडमिट भी नहीं हुआ है.
एडमिट करके रिवीजन सुनने का कहाँ नियम है?
नियम नहीं है, लेकिन वो 397 होती है. ये बोल रहे हैं.
Let me just see. I will just ask you to deposit some amount. सरेंडर कब किए हैं?
16 को।
बहुत बुरा हाल हो रहा है। चलिए, आपका केस सर, आपने रिटन सबमिशंस फाइल कर दिया है, हम उसको ना हम देख कर आए हैं उसको, तो हम उसको आई हैव हर्ड यू फुल्ली बोथ ऑफ यू, सो आई विल पोस्ट इट फॉर अ डेट ऑन जजमेंट, वो हम कर देंगे। अब 5 मिनट्स नहीं, अब सीधा जजमेंट पर आएगा, हम सुन लिया। नहीं, अब कोई क्वेरी नहीं है, हम पूरा फाइल पढ़ के अपना क्वेरी सब सेटिस्फाई करके आए। चलिए, इनका मैटर को ना एक दिन जजमेंट के लिए पोस्ट कर दीजिए। आज तारीख कितना है? 20। आज नोटिस है ना, 12 अप्रैल को पोस्ट कर दीजिए और जजमेंट उसमें लिखिए written submissions, written notes of argument has been filed by the respective parties. Post this case for judgment on 12th of April. 12th April. It will come for judgment. इनका tomorrow कर दीजिए। Serial number दीजिए। Serial number 46.